round of applause to Mr. Lewis.
Thanks. I appreciate this opportunity to talk to the DaVinci group, and feel free at any point to interrupt with questions, because some of this stuff is better interactive and better kind of as we talk about it rather than at the end. Just to kind of get me started, I'd like to know how many of you have already formed some sort of entity or more than one in your careers. Okay, so most of you have some background with, and probably do it yourself, because I know it's easy to do these days, forming an entity. Let me just go into a little more of my background. I've had kind of a hybrid experience in the legal world. I started with a big law firm in their corporate department, and being in a law firm and working as outside counsel is a very different relationship with the client. It's transactional. You go from project to project to project. You don't get to know the company as well, and it's in depth. And I found as I work with clients on a repeated basis that I really enjoyed the continuing relationship that you develop and the value you can be to a company, because as you get to know their business and get to know them, you can start to connect the dots when they do something on one end of the business, how it might affect the other end, rather than just doing, you know, a single transaction where you don't really know how the ripples might affect the entire company. So I made a decision early in my career that if I got an opportunity to go in-house, that's what I wanted to do. And after I'd been at the firm for 9 years and I made partner, realized that being a partner wasn't going to change my life. It was still, being at a big firm is still being at a big firm no matter what you're doing, until you get the corner office, which takes many years, more than I wanted to put in at a firm. So I got an opportunity at Evolving Systems, which was a very rapid growth software development company for telecom. They did things for Lucent and GTE and Bell South, various phone companies that were these rather large custom development projects. And I got to learn, you know, being both legal counsel for the company, but also on the business side. And something you don't see at a law firm is some of the business realities. It's very easy. A law firm is somewhat ivory tower. You know, you're trying to avoid first your own liability for malpractice, but you're trying to make sure that the legal bases are covered, and sometimes you forget the business issues, the practicalities, and why you can't always do everything according to some handbook. It has to be practical and, you know, somewhat modified to fit the facts. So the longer I've been in-house, the more I've kind of blended my way of looking at the legal side of things with the business side. My experience at Evolving Systems was about 5 years, and then actually a group of us from that company formed a startup. And I was basically everything that didn't have to do with sales or development. It was another software development company. Everybody else had technical background of some sort, and I did, you know, I was the CFO, I was the HR person, I was the office manager, and did the legal. And so, really, again, business became more of my background. The legal part was part of what I did, but I got a broad appreciation for what it's like to actually have to do a payroll, have to actually balance the books, and I do envy you guys. Unfortunately, I've never had a good idea in my life, so that's why I'm an attorney. But I really, honestly admire the people that do come up with these ideas and do start the businesses, because they have skills that I wish I had been able to develop myself. And since the time we sold our company, which was Peak Software Solutions, in the heyday of the .com, we were doing a software development project for a company in Silicon Valley. And we didn't know at the time, but they had hired us to do the project because we were a target. They needed a software development shop to help them develop their voice over IP technology. And so they came to us with an offer. You know, first they said, "Are you interested in being acquired?" And we said, "No way, we love what we're doing." Then they said, "What if we gave you $1 million per engineer?" And we said, well, what do you consider an engineer? Well, it was basically anybody except for me and the HR person and the accountant was an engineer. So it was an offer we unfortunately couldn't refuse. So, and basically at that point in time, and this was 2000, money was being thrown around ridiculously for acquisitions. And this company was actually at the forefront of the whole voice over IP industry. They were a company called Clarent Corporation that had the most voice over IP minutes being transmitted in the world. Unfortunately, they had a very creative CEO. They were public, and they believed that meeting their forecast was the only objective that mattered. And so he had some colleagues in Taiwan, and he would basically have them set up fake purchases of software, just ship some CDs out there, and eventually it came out that they had overstated their earnings for 4 or 5 quarters. They were delisted on NASDAQ, and the whole thing kind of unraveled at that point. And so then we went on a fire sale. We were acquired by another company that didn't know anything about what they were doing. So it's just been kind of an up and down. In the technology, it's probably not an unfamiliar story, but an up and down world. And the last few years, after going through that, I decided, after going through numerous acquisitions and restarts and whatnot, that I was going to more or less do it on my own, because that's the one way you can control your life. And I think that's what a lot of you are feeling in wanting to start your own business, is because you're getting tired of being shuffled around. So I've been doing kind of an in-house outsource environment where I provide the benefits of in-house counsel to companies that don't want or can't afford or don't need a full-time person, but would like to have some of that relationship. And so I have probably a dozen or so clients, some that I spend a lot of time with, some that they come and go as projects come and go. I've done a lot of work with Amadeus in the last couple of years, and they've been a lot of fun to work with. I'd like to start with just kind of a high-level view of the legal issues that you all face with a small business, starting a new business. And I understand the dynamics that you're facing. You don't have a lot of money. You certainly don't want to sink your money into legal, because legal is not a productive asset in most cases. So there's got to figure out the perfect budget for a very restricted cash flow business. When do you think you should have a lawyer? When can you do things on your own, etc. There are 3 basic legal needs that you have as a small company, whether it's a startup or a business that's a little further down the road. First thing is you have to have your entity. Second thing is you have to identify and protect your intellectual property. And the third thing is you have to have your generic document that you use to sell or license your product or service. And those are basically the core items. Now, number one is having an entity, and all of you have done that before, so you must have some good understanding of why. Why would you form an entity rather than doing something as a sole proprietorship? Well, the number one reason is limitation of liability. I think that's probably the reason most of you were driven to do that. And it's very important because it protects your assets, your personal assets, from liability that might be incurred by the business. It also protects the business assets from liability that you might incur personally. So there's a wall between you and your business that most people find appealing. And I would say 99% of the time I would have an entity when you're doing any kind of commercial type thing because of this liability protection. There are other reasons to have an entity, but that to me is the number one reason. Like one slide behind, unfortunately. Another question that often comes up is, where do you incorporate or form your LLC? And Delaware is a very popular venue for that, and it's primarily because that's where major corporations are located. The law in Delaware is very well developed on the corporate side, and they have corporate laws that tend to be favorable to the corporation and less favorable to shareholders. A corporation always wants to be able to maintain as much control over the operations without shareholder interference, which is the way they look at it. It also has a chancellery court, which is a special court that deals with corporate cases. And so if there's a corporate dispute in the state, it can be heard relatively quickly, whereas in a state like Colorado, you have to go through the regular civil court process, and the dockets are very busy, and it could take months and years to get your case heard. And a lot of major investors and venture capitalists prefer to have an incorporation under Delaware because of their familiarity with the laws and their confidence in the legal system there, the amount of case law that's been developed over the years. So that's what makes a Delaware incorporation popular, and for most, the vast majority of entities, it doesn't make a heck of a lot of sense to do that, especially off the bat. I think you should incorporate where it's easiest. It makes more sense for your business. And that will be determined by where you're located and where you do the bulk of your business. So for most of you, Colorado would be the logical place. It's simpler and cheaper to incorporate in Colorado because you don't need to have a registered agent like you would if you're incorporated in another state. So you have to find somebody to be your registered agent. You have to pay an annual fee, and they receive all your official notices, and then they forward them to you. If you're incorporated here, you can be your own registered agent, and you don't have to incur that extra expense or the extra headache of dealing with that. And you can always reincorporate somewhere else. So there's no need to, feel like you foreclose the need to be a Delaware Corp if you get an investment from somebody who insists on it. You just change and incorporate there. And for the most part, when you do a major funding, they're going to want to rewrite your articles and bylaws anyway. So reincorporating is just a small piece of the whole thing. So I would encourage you, unless you have a really good reason to not do it, to incorporate in Colorado. The next question that you grapple with is what kind of entity. The two most popular now by far are limited liability company and corporation. There are other choices, but very rarely used. There's a limited liability partnership, a limited liability limited partnership, there's general partnership, and I don't think I've ever formed any of those. So I think that if it's not an LLC or a corporation, it doesn't exist. There are some differences between the two. I'm going to go through kind of a high level and then more of a detailed look at those two entities. Just for some background, how many of you have an LLC? How many a corporation? So they're fairly equal. I'm surprised because LLCs have been so popular the last 10 to 20 years that it seems like almost everything people ask me to form these days are LLCs. But there are reasons for picking one over the other, and a lot of times it'll just be a coin toss. But let me tell you what the main differences are. Ownership of an LLC is in the members, and in a corporation it's shareholders. And members own an interest, and shareholders own stock. So there's a slight difference in that stock is more of a formal type of ownership interest, whereas a membership interest is more inchoate. It's kind of what you make it to be in your operating agreement. The management of an LLC is done through the members or the managers. You have the option of going either way. And in a corporation, it's done through directors who are elected by shareholders, and then through officers who are elected by the directors. The organizing document of an LLC are articles of organization, and the main operating document is the operating agreement, which you really should have even if you're a one-person LLC. You don't have to have it. You can go with what is in the statutes and then have everything else just kind of be informal, but it's always better to have an operating agreement for many reasons. one of which is to help maintain the fact that this is a separate entity, not really just an alter ego of the person running it. For a corporation, you have the incorporation by articles of incorporation, you have bylaws usually, and then a shareholders agreement, which kind of goes through the shareholders' particular rights vis-a-vis each other, including buy-sell. An operating agreement would usually, if it covers all the bases, have a lot of the same things in it as the bylaws and shareholders agreement. It would just be in the operating agreement, so you'd have this one document representing all of them. Both of them provide limited liability protection. The big difference that most people are interested in is how they're taxed. And as a limited liability company, you can either be a pass-through, which means that tax of the members goes straight through to them from the operating company and not in the company itself. You can be taxed as a corporation if you choose, or you can be taxed as a single owner, which is taxed the same as a sole proprietorship. So there's no, everything just it goes on to the individual, the one owner. But that's only for one person LLCs. For corporations, corporations are separate entities for tax purposes. And there are two types of corporations that you're surely familiar with, the C Corp and the S Corp. Those are products of the Internal Revenue Code. They're the same under state law. It's a designation if you choose to be an S Corp that you make with the Internal Revenue Service. An S Corp is taxed like a partnership or like an LLC in that it's a pass-through. So whatever ownership of the corporate, whatever the corporation earns in terms of profits, losses, are distributed to the members on whatever, on a pro rata basis. So really the big difference where the decision making usually comes out on LLC or corporation is in the taxation area. I want to talk a little more.
Question?
Sure.
On that chart, I actually just looked that up yesterday. We got another guy come in. Members and managers, somewhere in there said that's optional. If you want to call yourself CEO or president, you actually can do that? That's the question.
Yeah. The question was whether you can use titles such as CEO and president when you're running an LLC. And the answer is you can use titles. They're more, I'd say for outside purposes. Mm-hmm. Internally, you can define officers in your operating agreement and give them certain duties, but you still need to, in some place they have to be a manager or a member as well. But you can say manager, also CEO, or member and also CEO.
That's the way I read it, was the legal default is you're a manager or member,
Yeah.
and you can use all kinds
Yeah.
of names.
Tasks or responsibilities that are delegated to you like you would with officers of a corporation as well. The question is it still, rather than a C Corp with the rate changes that have been put into place for individuals, the C Corps are mostly taxed at a flat rate of 35%. So every dollar is taxed at 35%, unless you've got some tricky ways of hiding income like big corporations do. I'm a C Corp because as an attorney, I can't get liability protection for malpractice. It's never going to be protected by the corporation. But I have a health plan and I wanted to be able to deduct everything. So as a C Corp, I have to make sure that I distribute all the money to myself as wages, because if I leave anything in there, it's going to be hit at 35%, and that's well above my personal tax rate, even at the highest margin, let alone the average. So that's the problem, and that's where you hear a lot in the media about we need to talk about our corporate tax rates and maybe address the rate, because 35% is it's obviously a huge margin to pay. The question was, what about forming a nonprofit? I don't know a lot about it because most of my clients try to be profitable and want to distribute the profits to their owners.
Yeah.
So I don't know a lot about.
Well, being a nonprofit doesn't mean that you can't make money. And
But
being a nonprofit doesn't mean you can't earn money off the company.
Can you distribute to the shareholders or the?
Yeah, there's different mechanisms. I mean,
Yeah.
whether you're set it up through salaries or through
Right.
consulting contracts or
Yeah.
things like that. And you can sell nonprofits. It's not done often, but that is one option, so.
Yeah, I haven't had a lot of experience with them because most of the nonprofits I've been familiar with are in either charitable or education or some other less of a commercial where their ultimate plan is to sell the business or to sell interest in the business to third parties to raise revenue. So I unfortunately don't have a lot of experience with the nonprofit.
Yeah. One option that can be considered is to actually start as a nonprofit and then convert to a for-profit later on.
Right.
That's one of the options that you can.
Yeah, Colorado has actually, the statutes have been revised to make it a lot easier to convert between entities, especially from LLC to corporation. It's a little harder to go the other way, and I don't know how easy it is to do the nonprofit to for-profit.
Yeah.
If it's easy, then it's another option you can consider.
Well, the nonprofit can spin off for-profit entities
Right.
as well, so that's another option.
So Tom, what would you say, not to belabor too much, but what would you say would be the big ad for a nonprofit going in that kind of way?
The big advantage? Well, there's actually several advantages. Well, first of all, you can avoid a lot of the taxes starting out. Sometimes you can get grants, sometimes you can get money that's not available to for-profit entities for getting things kicked off. It changes the way people perceive you as an entity if you're a nonprofit versus a for-profit. And so sometimes if you're working on real bleeding edge technology, what you actually need to do is actually create a movement before you actually create a business. And launching a movement to create enough awareness about whatever this new technology might be is better formed in this nonprofit. So you can create association, you can create events around it, that sort of thing. So
the whole world of social entrepreneuring, doing business for a good cause or having something on the bottom line is also a good purpose as well as a profit motif. And stacking that deck to the favor of all the things in the business world as well as the interest of the outside world can bring energy to the whole process.
Yeah. One of the things about the Gen Y generation is that work should have meaning, that we need to have meaning in the work that we're doing, not just doing things to make money. And forming things under a nonprofit sometimes can convey that message easier than for-profit.
Yeah, the whole connotation of nonprofit is much more favorable,
Yeah.
and I think would have a definite impact on a lot of things.
Yeah, but you're not going to get venture capital money into nonprofits. You're not going to be getting loans and everything is very difficult for nonprofits. And, so there's lots of downside to it as well. So should be aware.
I wanted to delve a little more deeply into the liability limitation, only because it's something you want to achieve by having an entity, but you have to do certain things to make sure you're going to be able to avail yourself of liability protection. You have to run your entity as an entity and with the formalities that are required. And that means you have to do the organizational documents that I mentioned, an operating agreement for an LLC, and articles, bylaws for a corporation. When you have corporate action, you should memorialize it either in minutes or consents to act or something, so that it shows that you're approving contracts, you're approving the admission of new members, whatever types of official corporate actions you do, you want to show that you've got some formal documentation of that. You want to have your own bank account for the entity, and you want to use it only for the entity's business. You want to sign contracts in the entity's name, and keep your personal funds and your personal business separate from that of the entity. And the reason you do this is because there's this concept in law called piercing the corporate veil, which also applies to LLCs, where if your corporation or LLC has liability for something and it's very undercapitalized, in order to be able to protect your personal assets, you have to show that this really was an entity. It wasn't just a sham. It wasn't just an alter ego of your own personal business. Otherwise, they can pierce the corporate veil and go into your personal assets. So important to keep at least these formalities in place, be able to document that you're doing it. And it doesn't take a lot of effort to do that in order to have the value of preventing the corporate veil from being pierced. So wanted to kind of now go a little deeper into the differences between LLC and a corporation, because those are usually the decision you'll make when you form an entity. And as I said, the S Corp is one brand of corporation for tax purposes that's different from the C Corp. There are a couple of things about an S Corp that make it difficult to actually form and maintain one. You can only have 100 shareholders, which isn't going to be a problem in most cases, but if you're going to have more widely distributed ownership, that's a problem. You can only have one class of stock, so you have a common stock and that's it. An entity cannot be a shareholder, so you can't have another corporation or an LLC own stock in an S Corp. And for that reason, if you want the pass-through benefits of the S Corp, there may be reasons why you can't get that through the S Corp, so you have to look at the LLC. Now you can move from S Corp to C Corp at any time. It's harder to move from C Corp to S Corp, but it can be done. So you're not fixed in one or the other when you make the designation. So now, having gone through that, I want to go through some of the pros and cons of the two entities. The limited liability company can be very complicated. I mean, what you have with a limited liability company is really the ability to write your own rules on who gets how much of the profits, how much of the losses, and other distributions. You are not fixed like you are with stock, where a shareholder, it's $1 per share. You know, it's pro rata, it's right down the line. You can have different classes of stock that have preferences, but each class, each person has to be treated the same as the other people in the class. Limited liability company, you can just about do whatever you want. There are some tax limitations, but very flexible. But as a result of that, which is, the flexibility is a good thing, but you can have these operating agreements that are 80, 90, 100 pages. They're extremely complex and obviously expensive. So you got to weigh whether you need that flexibility and when you want to put it in the agreement because of the cost. Forming a corporation is generally cheaper if you have a very simple corporation, because you just have bylaws and a shareholders agreement that are pretty much standard form for everybody. And you can have the same benefit if you form an LLC, if it's just fairly standard LLC. But if you start to get fancy with a lot of the things in there, it can build up. The taxation, as I said, limited liability company is a pass-through. A C Corp, it's either taxed as in a separate entity, so 35%, but then when you distribute the dividends, it's taxed at the individual level as well. So there's that so-called double taxation. You can avoid that by paying money as compensation, because that's not taxed at the individual level as a dividend, it's taxed as compensation. And the S Corp, as I say, is also the pass-through like the LLC, but it has those limitations that I just listed. As I said, you can do almost anything you want with profits, losses, and distributions of an LLC. For a corporation, it has to be the same for each shareholder of a particular class of stock. One disadvantage of an LLC that people don't always focus on is self-employment taxes. That's the tax you pay in lieu of paying FICA if you're employed, and Medicare, and it's 15.3% for both the employer and employee half of it. You will pay that on the profits of the LLC, even if it's distributed as a so-called dividend. So that's a disadvantage, because if you have a corporation and you pay yourself a salary of $20,000 and dividend yourself $60,000, you won't pay the 15.3% on the $60,000. In an LLC, they're going to look at it and say, how much of that $80,000 should really be salary and how much should be classified as a dividend or a pass-through of profits as opposed to compensation, and they'll apply the whole 15.3% to that. So that's a consideration. If you're, the limits on the self-employment tax, I think this year is about $120,000 and then it goes away. So if you're going to be earning or distributing more than that, it becomes less and less of a factor. But under that threshold, it is a factor. In terms of term of existence, an LLC only exists as long as there's a member. And so if you lose all the members, the LLC has to be dissolved. Corporations are permanent, perpetual. The stock gets passed down through, assignment or a sale. And you can do the same thing with an LLC. You can sell or assign your LLC membership, but it's a more formal process. You usually need approval of the other members to do that. It's not as mechanical as a stock transfer is. So those are the main issues. I think it's always just a question of looking at your own business and what your needs are, your own financial situation, to determine which entity is the best way to go. And either one you pick, since you've all been online forming one, you realize it's very simple. The question was, can you promote a manager to a member? No. A manager is a totally different concept than member. Member is ownership of equity, and equity can only be transferred from one member to another or from the LLC issuing it to a member. And there has to be some compensation, or consideration paid for it that meets the threshold for what's reasonable for what they're getting. So you could have a transaction where another member, if a member is going to resign or passes away, that they could transfer a membership interest. For,
let's say it's 25,
yeah.
3, 10, whatever.
Well, they have estates, so they could pass through those laws, probate or through a will. So that's how you would handle that. When you go online to form either of these entities, it's very simple. It's a one-page form. You just type in a few names and addresses, and you pay a $50 fee. So they're both easy. They both require a registered agent, which is the person who receives notice from the state, or if you have a legal action against the company, they receive the summons and complaint. Sure.
Are you saying that the SOC Secretary of State actually has that fill-in format?
Yeah.
The LLC?
Yeah, the question is the Secretary of State, what format do they have to form these organizations? Actually, on my next page, it's very, this is the page you go to, and you just pick what kind of organization you want to form, and whether it's a new or an existing, whether you want to file for an existing organization, a new document, or you want to form a new organization. And it literally is something you can do in 15 or 20 minutes. And then you just...
All I have on that was, as far as doing the operating agreement, which is personalized,
Yes.
either a tutorial or anything on the web.
Question is there anything on the Secretary of State's website about operating agreements? There isn't.
Or I mean Google.
Oh yeah. If you were to Google operating agreement, you would find plenty of places that would be loving to sell you one for a certain amount of money, nominally $20 or $30 or less, or you'll find some that are free, and they're probably okay for starters. If it's just a 1 or 2 person LLC and there's not a lot of really special provisions you need to worry about. The question is, if you file in Delaware, do you have to go? No, this is for Colorado. You would go to their Secretary of State. I think they also have a web page where you can organize the entity, and the other states all do too. It's become very automated and much easier to form entities, and cheaper because they're doing everything online. this $50 fee, I think it was $100 a few years ago when they accepted paper. And then to do your annual report, which you have to do every year in Colorado as an entity, I think they charge $1 now if you do it online, and $25 if you do it by mail. So it's actually gotten much cheaper and easier with the internet. So this follows up on the question you asked. The documents to organize at the state level, very easy, but the documents that you need to prepare, like an operating agreement, bylaws, or shareholders agreement, they can be more expensive depending on how much customization you need. And I've never used LegalZoom or any of those services, so I don't know what quality of materials they have, but there's probably something there that works as a starting point. And if you get to the point where you're bringing in new investors or venture capital, then you can work on what you have, and you can be sure your investors are going to want to do that. So I'd say, though it probably costs me business, is try to do as much yourself as you can, and if there's a few questions you have, you can ask those to a lawyer and save yourselves quite a bit of money. Another area I really wanted to dwell on, because it's something I think people often get confused, is the name of your business versus a trade name versus a trademark. And when you form an entity, you should really be thinking about all three of these things at the same time. A business name is the name you register your business as with the Secretary of State. So, if it's John Smith Company, that's your business name. And in order to get a business name to be accepted by the Secretary of State, it has to be distinctive from any other name that's already being used in the state of Colorado. But the level of distinctiveness is very low for a business name. So if somebody's already incorporated under John Smith Company, you can incorporate as John Smith Services Company. You just have to have one word in there that distinguishes you from that other entity, and you'll be accepted for purposes of incorporating or forming an LLC. Now, the word company or corporation or limited or whatever end word, you have to have one of those for any entity, and varying that word will not be permitted. So a John Smith Company is the same as John Smith Inc. or John Smith LLC. You have to have another substantive word in there. You can go on the Secretary of State's site before you file your documents and check to see if the name's available. And you should do that so it doesn't get rejected. But again, very simple. You can add a word here or there, make it work. What you run into the next situation, which is a trade name. A lot of companies will incorporate under a name like John Smith Company, but do business to the public under another name. Like, let's say they're a Grease Monkey franchise. You have to file a trade name application in order to do that, so that people in the public can link up who they're actually doing business with. So this, again, is a very easy thing to file, and I think it's a $10 filing. And then the third thing is a trademark, which is something that identifies the goods or services that you're selling or marketing, as opposed to the name of the business. Now, they can be the same or similar, and many times they are, but trademarks are harder to get and really take a lot more thought than your trade name or business name. Now, there are two kinds of trademarks. There's the unregistered variety, which is symbolized by the TM, and then there's the registered one with the circle R. A trademark with a TM, in order to use that, you just have to have a name that you're using to sell goods or services. There's no registration required. There's no formalities required. It's totally based on your usage, and it's limited to whatever geographic area you're doing business. So if you're offering your products in Colorado under a trademark, then you would have trademark protection, which means that whoever uses it first for a particular line of products or a particular business area would have precedence over someone else coming later. But it's a narrow trademark. So you can have Apple Computer, you can have Apple Plumbing, you can have Apple Records, various different names for this that are the same, but they're in different industry sectors. A registered trademark gives you broader protection. It's a national registration. You still have to use the name in commerce You can't just take a trademark and protect it without having actually put it into use. You can do that for a year, but after a year you have to actually be using it. And there are other benefits to registering your trademark in that you get more damages and more remedies than you have from an unregistered trademark. But registering a trademark is a process. It usually costs around $2,000 between filing fees and legal fees. And it could be more because you have to register your trademark in particular classes of services. And you're going to have to argue to the Patent and Trademark Office that you really are different from anyone else using the mark, that you are entitled to have the mark in those particular classes of services. And there can be some back and forth, which increases the cost of obtaining a trademark. You also need to do trademark research before you file a trademark to see if anyone else has the mark that's similar. And so you won't be bounced out of there right off the bat. Sure.
Can common names or phrases be trademarked or in public use?
Now that's something, the question is, can you trademark a common name or phrase? Generally, no, because if it's just merely a descriptive thing or part of the standard vernacular, unless you're using it in some very different way, you can't do that. I've heard, like, what was it, Donald Trump who wanted to trademark "you're fired." Maybe you could do that in connection with a TV show name or something like that, but not as, no one else can be prohibited from saying "you're fired" in any, even Trump can't get that. When you're, trademarking is something you really need to take a lot of time looking at if the name of your product is something that's going to be important to you. You really need to develop a strategy to protect the mark. You need to integrate that with your business name, with your domain name, and with your trade name to make sure it all kind of dovetails together. So if that is one of your areas of intellectual property, it's something you start early, right at the time you organize your entity, because that's when you're filing your entity name. No, there are international trademarks as well. And
It's a different process?
yeah, you have to do a different process. There's some streamlined where you can get, the question is how do you get an international trademark, or whether you filing in the US will give you protection outside the US, and it doesn't. You need to file in other countries, but you can file in some as a block. There's several blocks of countries that if you file in one, it works for all of them. So it is something you have to look into if you're going to be multinational. So the second thing, that we kind of bled into it a little bit with the whole trademark, trade name thing, but
Just an interesting example, I think, on trademark. Even though Microsoft got a trademark on Windows, they sued a number of companies for infringement, and no court has upheld it yet. Because Windows was a generic term, and they should have never gotten a trademark on it.
yeah, I mean, they were probably able to do it only because it never was used for software applications before. But the strongest trademarks are words that are really made up out of nowhere, like Xerox, because there's no other Xerox word in the dictionary. The question is, could trademark Google Candy be started up if you're really going to use it for candy? Some trademarks become so pervasive that they develop enough identification that it would confuse the public, and they would associate the fact that it's probably Google making the candy. So Coca-Cola is, companies like that have such a universal acceptance and knowledge that I think you'd be out of luck on that one. But if it's a lesser known company, all right, so let's see. It was a good idea. So the second big legal area, once you've formed your entity and figured out where you're doing business, is going to be identifying your IP. And first in that is patents. Do you have anything patentable in what you're doing? And if so, you want to start early getting patent protection in place, because this is going to be a significant value to your business. You can get what's called a provisional patent, which is a 1-year protection that You start the priority date, the date you file the provisional. They're relatively informal. They don't have to have all of the bells and whistles of a regular patent. You could probably file one without legal help, but it would help to have legal help because that would help when you file the regular patent to make sure that they fit together well. But it's one of those areas where if you're a patent or invention type business, you want to look at early on, because the earlier you get it underway, the better off you're going to be. And again, not a cheap thing. When I used to ask patent attorneys a few years ago, what does it cost to get a patent? They'd always say 10 to 20,000. I don't know if that's still the case. It would always take 2 to 3 years, it seemed like. We're getting an office here in Denver soon, so maybe that'll help. But it can be well worth the investment because it's the one area of intellectual property that is a real shield against anybody doing something like it. Now, there are ways around it always by writing a patent claim a little differently than what you have, but it gives you a real huge leg up. Plus, having patents is something that investors love. Yeah, you could talk about patents a long time, especially with these patent trolls, which is obviously a derogatory term, but there's a lot of good and bad in the patent system, especially with software, and I'm hoping that gets ironed out. The next type of intellectual property, and probably the most common and most important for most of you, is trade secrets. A trade secret is a very broad class of intellectual property. It is anything that is secret and of value to a business. And that can include formulas, customer lists, business plans, methods, processes, designs, a vast array of things. There's no registration or filing requirement to have a trade secret. All you have to do is have something that you keep secret and have it be of value. But you do have to keep some steps in order to make something secret and be able to demonstrate to the world that you consider it a trade secret. So one of the most important things is to mark things, obviously, proprietary, confidential, if you have them in written form. Another obvious thing is to use non-disclosure agreements. And if there's one document you need to get as a business, it's an NDA. You don't want to start talking to anybody with any of your proprietary information until they've signed one. And that includes potential customers, potential investors, anybody, vendors you might do business with. And so have a good form of NDA and make sure you use it. The next step in protecting your trade secrets is to get an agreement with people that work for you. And this is both the employee side and the contractor side. And those agreements usually cover confidentiality as well as who owns the work product they develop, who owns their intellectual property rights in the work product. You want to have that well defined, and obviously you want it to be owned by your company in most cases, unless there's some other understanding with the employee or the contractor. The other things you accomplish in these agreements is to make sure that your employer contractor doesn't bring in other parties' intellectual property and use it in your products, because then you'll have a problem with potential infringement. So that's a key issue. Some people end up being charged in a lawsuit with using intellectual property from one of the previous employers of the individual. You want them to state in their employment document or their contract that they're not going to bring in those materials. The question is, do you need an attorney, or do you need an NDA with your attorney? And you do not, because there's a built-in attorney-client privilege and relationship where the attorney's not able to disclose confidential information to anybody else. So you don't need anything with the attorney. Even before you engage the attorney, they can't use the information you disclose in your pre-engagement. The question is, what do you do if you're using someone else's product in your product? You should have a license from the creator that allows you to do that, and it should be a written license. So they would say you have permission to use this intellectual property with your property in this way. If you're using freeware or shareware, you want to make sure that whatever terms or restrictions the freeware or shareware has on it allow you to use their material in your material. Because a lot of that stuff is under certain licenses that say you can't commercialize or use the end product. So you have to be careful about stuff you pull up under one of these GNU licenses or one of these other freeware licenses to make sure that it's okay to sell that or use that as part of the end product. The question was, can you use YouTube clips? That's a copyright issue, and you can't without permission unless it's a fair use, and fair use is pretty limited. You can use it if it's news coverage, if it's a parody, but not for other commercial purposes without permission. Yeah, copyright it's not common, but there's a copyright the moment you put pen to paper or finger to a keyboard that you don't need to file. You can file, and it has benefits just like the trademark benefits, in that you get more remedies and more rights by doing it. So if you're going to have a product that is, a publication type thing or software code, you want to consider copyright protecting it. But generally, those are usually protected as trade secrets. And so you get the protection you need as long as you can prevent people from reverse engineering and such. So you don't necessarily need the copyright, but it's another way to go. For the copyright? You mean when you register?
I'm just wondering, even though you don't have really formal rights the way you would with a trademark or something else like that, or a registered trademark versus the regular other trademark, is there something that distinguishes that informal copyright behavior?
The formal copyright gives you better damage claims against infringers. If you didn't, you'd still be able to go for infringement claim. You'd still be able to do that. It's based on when it was created. So you can put a copyright notice on anything. You just put copyright 19 whatever or 2000 whatever, and then your name or the name of the copyright holder. But you don't have to put it on it to get the copyright protection. The question was, what happens if a non-employee, and this would actually apply to both employees and non-employees, you would want them to assign all inventions to you in their employment documents.
So how did they work?
The same thing. You'd want them to assign all inventions, because it's even more difficult because you don't have the work for hire presumption with contractors like you do with employees. So you want to have in your contract agreement that any inventions, any work product, any copyrightable material that they create is full property of your company.
But how about they create like 10? How about that's their job is to create?
Still, yeah, you want everything. Yeah, but they have to do it by contract of their contractor, because otherwise the creator owns the intellectual property. I have, I'll go quickly over the last point because it's actually pretty self-evident, and that is make sure you have a good sales agreement or service agreement or license, whatever your product is, with your customer that protects your liability, that's clear on what the ownership of the intellectual property is, that disclaims damages for consequential damages, that defines whatever warranty terms you have, because you don't want to be left with things that are oral or undefined. It's never a good place to be. So develop a good form agreement that you use with your customers and use it as religiously as you can. And try to use your form rather than their form, because your form will always be better for you than theirs will be. And the other just high-level points are, it's a good habit to get into storing and organizing your documents somewhere right off the bat. You can use Dropbox or one of those type services. It'll help your life a lot whenever you go to get any kind of funding, because you already have it all put together. And you can just give somebody access to it, and they can start looking at it. If you have to go do it after the fact, it's painful, it's time consuming, but if you keep it up as you're going along, it'll be a lot less costly and painful for you. And I was going to make a speech about why you shouldn't do venture capital or sell your business, because I've been through so many of those and I've seen them ruin the culture of a company and ruin the lives of many employees. Obviously, everybody wants to do well financially, and that's a consideration, but think about the people you're going to leave behind, because it's a rather tumultuous experience. The culture never survives. You know, maybe never is too strong, but in my experience, it rarely survives. The employees, they'll always tell you they're not going to downsize, but it happens every time that I've been through. These economies of scale are a shortcut for saying we're just going to move it to headquarters and everybody else is out. They're much more likely to outsource internationally. So this beautiful business that you've dreamed of having and built is, you know, you won't recognize it within a couple of years. And my experience was I enjoyed being my own business owner more than anything else I've ever done. And you can make a good living at that. So, and not only that, your kids would have a place to go. The kids in my family who have a family business to go to are all employed. The kids in my family who don't have been laid off 4 times and are still always struggling to find that place. So there's a lot to be said for developing it, nurturing it, and keeping it. That's my speech. Thank you.